SJC-11828, Commonwealth v. Louis Costa.
Mr. Apfel, good morning.
Good morning, Your Honors. David Apfel, with me is Kate Sadek from my office on behalf of Louis Costa. Louis Costa was accused and convicted of committing two horrible murders that occurred back in 1986 when he was 16 years old. Since that time, since 1986, Louis Costa has been in prison for a total of 28 years, and he has, in that time, become a model of maturity and rehabilitation.
It sounds very impressive, and I'm sure it will impress the parole board when he comes up for parole in a couple of years. Why isn't that the appropriate process?
Well, the reason he has been delayed in coming up for parole is because he unlawfully received 2 consecutive sentences back in 1986.
Well, they weren't unlawfully imposed. They weren't unlawful when they were imposed, and all we've done is concluded that life without the possibility of parole isn't appropriate for a crime committed when the individual was a juvenile, but that's it.
Substantively,
there's a possibility of parole here.
Understood. Sure. Substantively, when these sentences were imposed, they were not unlawful. And as the constitutional defect has been cured by this court in Diachenko, the 2 sentences running consecutively right now are not necessarily unlawful, at least for purposes of this argument. I'm not pursuing or I'm not claiming that the sentences themselves are unlawful. The constitutional infirmity here is the unlawful procedure by which those consecutive sentences were meted out back in 1994 when Mr. Costa was sentenced.
So they were they weren't unlawful, but the procedure that was followed by Judge Mulligan when he sentenced them Mr. Costa in 1994 was unconstitutional?
The sentence was.
Well, the sentence we know was unconstitutional, and the sentence itself has been cured. But I would suggest that what I'm saying here is that there was an abuse of discretion on the part of Judge Mulligan, and there was because he imposed consecutive sentences for 2 murders. Because he can impose consecutive sentences without taking into consideration, as he must under Diachenko, as he must, Costa's youth and other youth-related or age-related mitigating factors as set forth in Miller.
Do you need to... do you actually need to reach the constitutional question? I mean, in the sense that if you have 2 consecutive mandatory life sentences, which can no longer be, those are unconstitutional, as in Diachenko 1, then as in often the case, when something is declared unconstitutional, it goes back for resentencing. Mm-hmm. And so there is a certain ability of a judge, and since Judge Mulligan has retired, some other judge, to look at that and figure out, okay, in this new landscape, what would I do?
I agree.
So
I don't
you
think
wouldn't
the
even
court-
need to go to the,
I don't think the court needs to reach the constitutional question of whether or not there was a procedural due process violation. I maintain that there was a procedural due process violation, but I think this could be construed in a much simpler way. I mean, the case is, by and large, in some respects, on all fours with the case of Commonwealth versus Hall, a case that is 369 Mass 715. It is not cited in either of my briefs.
it's cited in one of
It
the
is
amicus
cited
briefs.
in the amicus brief that Mr. Cunha and Mr. Hope submitted on behalf of James Costello and discussed in that case. But in the Hall case, Hall was sentenced. Hall was convicted of 2 murders, and he was convicted of armed robbery. And he was given the death sentence, the death penalty, on both of the murders, on each of the murders, and an on and after life sentence on the armed robbery. The death sentences are then set aside by this court in Hall after Furman comes down from the Supreme Court. And it is deemed that those have to be converted, just like Costa's 2 sentences of life without parole need to be converted to life with the possibility of parole, with parole eligibility. They're converted to simple life sentences, and the court then remands on the issue of whether or not the life sentences, it affirms the life sentence even on the armed robbery, and this court says on remand, it will be a matter of the court's discretion to determine whether or not what had been an on and after sentence will be a consecutive sentence or run concurrently. I would suggest this same thing, just as a simple procedural matter, is possible here, and that's what Judge Locke determined. Judge Locke determined that he had the authority, very consistent with Diachenko and Brown, certainly in keeping with the spirit of Diachenko and Brown, and if not the letter, and I suggest it's in keeping with the letter of Diachenko and Brown, that he has the authority to consider whether or not these sentences, which are mandatory life sentences, no question about that, we're not questioning that here, but whether or not they need to run consecutively or concurrently. And all we're asking for is a hearing. We're not, I strongly believe that Mr. Costa has earned concurrent sentences.
But we can't go to that. We can't go to post-sentencing conduct to determine whether or not his sentences should be changed. Can we really?
The short answer is yes.
How can we do that? We say you've been really good in prison, therefore 20 years later, I'm going to go back and change your sentence so you can be paroled earlier. Is that permissible?
Justice Corey, there are two respects in which you can go back. One is in 1994, Mr. Costa already had a track record of 8 years in DYS and in prison, which was never taken into account by Justice Mulligan. So that information about what he had done in DYS, what he had done while he was out on bail for a year, his prison record and the arc of his prison record and how he had conducted himself and begun to exhibit maturity and rehabilitation in prison can certainly be taken into account.
20 years later.
Well, that's all information that was available in 1994.
20 years later, you just said he's done a great job in prison, so that's a good reason for us to revisit this.
The good reason for you to revisit it...
Good reason for parole.
No. The good reason for this court to revisit the issue of consecutive versus concurrent is the language of Diachenko. The language of Diachenko that says, this court has reserved for another day the question of whether or not discretion is always required as a constitutional matter with respect to juvenile homicide sentencing. But the court has not addressed, and what I'm asking you to address here, is the issue of where it is clear that discretion is available. Well, the court has addressed it. The court has said in Diachenko that where a sentencing judge has discretion, where he's faced with the possibilities of one sentence versus a harsher sentence, in making the determination of whether or not a juvenile homicide offender should receive the harshest possible sentence, the court must consider age and other age-related mitigating factors.
And the Judge Mulligan, didn't consider that at all? Wasn't even before him, is what you're saying?
Well,
I thought the argument was remember his youth, and I thought that was the argument for concurrent sentences that was made at the time.
There was an argument that lasted maybe 5 seconds, saying that his youth should be taken into account, and Justice Mulligan blew right past that, didn't say a word about it. We don't know whether he considered it or not. What we know is the words that he uttered, and the words were to focus exclusively
on the horrific nature of the double murder.
On the horrific nature of the crime.
Seems perfectly appropriate to focus on that.
Well, it's perfectly appropriate and part of the equation.
And indeed, your client had actually gone through a very extensive transfer hearing when issues of his rehabilitation were litigated extensively, or his potential for rehabilitation within the juvenile system.
Some 8 years earlier, he had gone through that system, where a very different question was in play. The question in play was whether or not
he could be rehabilitated as a juvenile.
Within the juvenile justice system, right. Namely, whether he could be rehabilitated in the year and a half that remained while he could be kept in DYS.
He'd be kept longer than that, but that's okay.
Well, up to 21. So
it was
the potential for another 3 years.
In fairness to Justice Mulligan, what were the practical consequences at the time of sentencing of a concurrent versus a consecutive sentence?
There weren't any.
Unless he was a soothsayer, he didn't know what was coming, and he was making a statement, presumably, about his perception of the crime, but not taking into consideration.
But, I mean, there really weren't any, because it's life without parole. So
that's right.
2 lives without parole is the same as 1 life without parole.
That's right. Albeit, I mean, the argument was made at the time suggesting that there's some difference, at least on its face. There's a suggestion of a difference between consecutive and concurrent. But Justice Mulligan definitely didn't, appreciate that there could be consequences for Mr. Costa to that decision.
Well, I mean, I gather there would have been no consequences but for the change in the law.
I agree that that's true.
Is your constitutional argument, I just want to see if I have this correctly, that our sentencing structure leaves it to the legislature to say that this is sort of Diachenko 1, that a life sentence, that's what they have chosen for murder, even if it's a juvenile who commits the murder, and we say, okay, that's the legislative choice, but there must be an eligibility for parole. But are you saying what's different about this is Miller talks about the sentencer being able to take into account, and the one decision that is up to a judge is whether, in a case where there are 2 homicides, is whether to do this consecutively or concurrently. And that's not a decision for the parole board. That is a purely judicial decision. So is that your argument?
That is the argument.
That is why it is not just appropriate, but are you saying that that's constitutionally required, that at this point we go back and a judge needs to make that decision?
The short answer is yes. The longer answer is, and I think it's helpful. It's helpful to me in thinking about this, and hopefully helpful to the court. Instead of thinking of this as a case or as a crime that occurred in 1986 and an operative sentencing that occurred in 1994, assume the exact same crime occurred today under existing law. And Mr. Costa was convicted today in 2015 of a double homicide. The issue at sentencing would be whether or not those sentences should run concurrent or consecutive. And on that issue, there can be no question that under Diachenko, under Brown, under this court's other juvenile jurisprudence, the court would have to consider on the question of whether or not the sentence should be, under current law, 25 or 30 years or 60 years.
So so let's assume for a moment
Youth
that
and
he
other
was
youth factors.
sentenced, committed the crime today. What would he be facing for first-degree murder?
What would Mr. Costa be facing?
Statutorily.
Statutorily, he would be facing, because he was convicted on a theory of premeditated murder
Right.
and not cruelty and atrocity,
Right.
he would be facing 25 to 30 on each of the murders.
25 to 30 on each murder.
And I would suggest to the court, under current law, if it came up, if he were to
Say
receive
25 to 30, you mean he would be eligible for parole
after 25 to 30 years. on
after
each one.
25 to
That's
30
correct.
years? Okay.
But
Which is sort of where he is now.
sort of where he,
He is now, 30 years, he's eligible for parole.
yeah, but he's somebody who could have been under extant law and under this court's law eligible for parole after 15 years. I would suggest that
Okay, but you could have if the world had changed.
But it now has changed.
Yes.
It now has changed.
So now he would be subject, even on one murder, to minimum 25 years before parole eligibility.
That's true, and I would suggest that if he
That's
were,
changed too. So we've got a number of things that have changed here.
but
You
Justice-
want the good side of both of them.
No. Justice Cordy, if he received the double sentence, then I would suggest that would be unconstitutional.
Really?
Yes.
2 murders.
2 murders, because under this court's holding in Diachenko, any sentence that is the functional equivalent of life in prison for a kid without the possibility of parole is unconstitutional.
3
And
murders? 4 murders? Where are we going with this?
Well, if
Does it matter anymore?
If it's a 60-year sentence, if it's a 90-year sentence, then we're talking about the functional equivalent of life without parole. And what the court has recognized is that as a constitutional matter, both legally and physically, as a constitutional matter, children are different from adults when it comes to sentencing. And therefore, there has to be consideration of the development of the adolescent brain and also of the role that age played in the crime.
And of the horrific nature
Of course.
the crimes,
Of
which are
course.
the most serious crimes that can be committed.
Absolutely, no disagreement there, and that has to be taken into account as part of the calculus. But likewise, coming back to your earlier question, I would suggest it's a no-brainer as to what needs to be considered if the crime is committed today. Likewise, given Diachenko's holding that it applies retroactively, age and age-related factors have to be considered with respect to Costa, and one of those factors is the possibility of rehabilitation. And on the issue of possibility of rehabilitation, it is perfectly appropriate not to turn a blind eye to what this individual has done over the course of the last 25 years and the strides he has made and the accomplishments that he has made as part of considering whether or not he should receive consecutive sentences or concurrent sentences. And I think this court has decided in very similar circumstances where there is a remand and a vacating of sentences years after the fact, that it is appropriate to consider post-sentencing conduct, in this case, post-1994 conduct. And I think the best case on this is cited in our brief. It's Commonwealth versus White, which is at 436 Mass 340.
Thank you.
Thank you, Your Honor.
Good morning, may it please the court. John Zanini for the Commonwealth. I think there are 3 separate strands of questions or issues going on here. One is whether there's a substantive due process violation by the sentence which Mr. Costa is currently incarcerated under, or the 2 sentences. And the answer to that, if I understand Mr. Apfel, is no, there's no substantive due process violation.
Or at least he's not pressing that argument.
Not pressing.
He's not. The amicus Attorney Cunha, who's here on behalf of Mr. Costello, suggests there's a substantive due process and that 30 years categorically is unconstitutional. And I suggest the court should reject that argument to the extent you entertain it. When you have two murders, there is nothing to indicate that two sentences of 15 years that are consecutive is in any way disproportionate to either the offender or the offenses.
Except that at the time, back in 1994, and I'm looking at the transcript of the sentencing hearing, Judge Mulligan believed that his discretion, to the extent that he exercised it, was, quote, somewhat symbolic. And to the extent that Attorney Bolero, a highly experienced criminal defense lawyer, believed that the only thing that was available, and this is understandable because that was the law at the time, that the only thing that might possibly impact the decision to impose either consecutive or concurrent sentences was the manner in which Mr. Costa might be treated by the corrections officials. And we now know, as a result of Diachenko and Brown, that the entire sentencing structure has changed. That the range of discretion and the purpose under which discretion could be exercised is no longer merely symbolic, but it actually affects whether or not somebody would serve 50, well, first of all, that he would be eligible for parole. That has completely changed the formula. And the other thing that has changed it is that there is a meaningful and significant difference between consecutive and concurrent sentences. So the entire sentencing structure has been changed in a way that nobody contemplated. And perhaps it should go back for a hearing on sentencing so that the discretion, the judge's discretion, and meaningful argument as to how the discretion should be applied will look today, which is very different than it looked in 1994.
I respectfully disagree for two reasons. First of all, the sentence was lawful when imposed and is lawful today. And in Diachenko 1, and in Brown, and in Okoro, it's clear if you read those three cases, you deny him any relief, the case is already over, it's already decided. In Diachenko 1, the court specifically said, contrary to Diachenko's contention, he's not entitled to be resentenced, given that he was not improperly sentenced in the first instance, but was only denied the chance to be considered for parole. Mr. Costa is now parole eligible. What he's really asking you to do is change the parole eligibility date.
Can I ask you on that one? You have a footnote 8, and I'm not really sure I understand what your position is with regard to parole. I'll read it to you. It's very short. The only possible change that could occur after a new sentencing hearing is to change the date of the defendant's parole eligibility. This assumes that the board will treat his sentences as aggregated for purposes of his parole hearing, rather than paroling him from one life sentence to the next.
Right.
So you're saying that one possibility here is for the parole board to say, all right, we're considering you after the first of your 15-year parole eligibility, for after one, and then so we could grant you parole on that, but you're only paroled to your next life sentence.
It's a whole separate issue, which is not raised and it's not in front of the court.
Well,
there's a statutory change, there's a parole board interpretation, there's an aggregation, and they view it as 30 years and parole eligible. That's the current state of the law. Okay. Whether or not someone's going to challenge that interpretation is an open question. But right now, he's asking you to take his 30-year parole eligibility date for all intents and purposes and convert it to a 28-year date. Assuming for a moment his sentence is unconstitutional because it's disproportionate, then you would get to the question of remedy. Do you send it back for a resentencing, or do you just change his parole eligibility date and say, okay, you're parole eligible today, Mr. Costa? In Brown, the court was clear you don't have some kind of open-ended sentencing hearing. You have parole eligibility. That is the remedy for an unconstitutionally disproportionate sentence. And in Okoro, this court, Justice Bosford recently wrote this opinion within the past few weeks, and said, look, you're misreading Miller, essentially, and Miller does not apply in Massachusetts, and the Miller factors don't apply, and we don't have Miller sentencing hearings.
Hold on. That's not what it says.
And that's my interpretation. I could be wrong. And
Uh,
there's a reason, but let's wait. There's a reason we don't have Miller sentencing hearings.
Okay, but you
And
still haven't answered Justice Spina's question,
I'm
which
on my
is,
way.
you're on your way?
way.
Okay, we're waiting for you to answer the question that he had only a symbolic, the decision initially was symbolic, and now it has consequence, and the question is, why does he not have a hearing in which the consequences are considered? That's what we're waiting to hear.
And the reason why is because the Miller factors only apply to death penalty cases, number one. Number two, this court has said the only sentence that's akin to the death penalty is life without parole. We don't have that in Massachusetts under Diachenko for one murder, one juvenile. You don't have life without parole. So you don't have a sentence that's akin to the death penalty, so you don't have a Miller hearing. If you got into a situation like Justice Cordy suggested, where you have a juvenile who, God forbid we ever get there, commits a series of murders or other heinous crimes over a period of time and is subsequently brought to trial, either in one trial or a number of trials, and you get into a sentencing situation where, because there are multiple murders, multiple other crimes over a period of time, where you might be facing aggregate sentencing that could amount to life without parole, maybe then you get to the Miller hearing. And one of those judges in one of those trials, probably the last one in line, has to decide, oh, do I add another from and after sentence for this new and different crime, this new and different murder victim, which is now going to somehow effectively become life without parole? But we haven't gotten there yet. What we've got is a line of cases which makes it clear that we don't have Miller hearings and we don't have Miller apply in Massachusetts when you have a parole eligibility date and you don't have life without parole and you don't have the death penalty. If we have one of those cases, then we'll get to the issue of, do you have a Miller hearing, or is it constitutionally prohibited to get to that sentence?
And are you relying upon U.S. Supreme Court law or our law?
I'm relying on, I think primarily there's three cases here. There's Diachenko 1, which is 466 Mass, where the court said the remedy for an unconstitutional life without parole sentence, the remedy is parole eligibility. The court specifically said the sentence is lawful.
Right, but in all those cases, to my knowledge, there was only one victim, correct?
Correct. And
this is the first case where we've had two victims.
Right.
And so why should we be bound by something that we would not have any reason to have considered in Diachenko and Okora as to whether or not that language should apply when there are two victims?
Right. Two reasons only, logic and experience. And so logically, if you're going to declare that a 30-year sentence is unlawful and disproportionate, then you would get a remedy. If you're going to declare that it's unlawful and disproportionate, which you only did in Diachenko because there was no parole eligibility, if you're going to declare this sentence unlawful and disproportionate, I suggest the new murder statute for juveniles is likewise constitutionally defective. So you're going to get rid of the 30-year sentence parole eligibility dates that exist for first-degree murder in the new statute. So you can't very well grant him relief here unless you find that his sentence was unconstitutional and disproportionate, that it shocks the conscience.
Why can't we simply say that the judge at the time of sentencing made a decision which he, according to, as is read by Justice Spina, verbally stated was purely symbolic, had no practical consequence, and to say should go back to a judge who should recognize that actually that decision does have practical consequence, and a decision should be made in view of that practical consequence and not speak to whether or not it would be unlawful. In fact, that argument is not being made. He's not contending that if there were to be a rehearing and Judge Locke were to say, I think the on and after was actually the appropriate sentence, and I impose it, that he essentially has said, we're not going to come back and challenge that.
So I think there's three reasons, and I'll try to remember all. One is that there would be no Miller hearing, because even if he got 15 plus 15 from and after, parole eligible at 30 years, that's not life without parole. Mr. Costa's been in court. I've seen him in court. He's hale, healthy, and hearty. There's a photo of him in the briefs in his current, more or less his current state, and he's not contending that that would result in, that 15 plus 15 would result in an unlawful sentence. So unless you're going to find the sentence, in fact, is unlawful, I don't see how you can simply vacate a lawful sentence and remand it to a judge to impose another lawful sentence. Also, if you vacate it, he says we get to apply the Miller factors at this new hearing. Only you don't apply the Miller factors in Massachusetts because he's not getting the death penalty and he's not getting life without parole. And that's what Okoro and Brown and Diachenko all say. You don't apply the Miller factors unless you're going to get life without parole, and you don't get that in Massachusetts. What you get is parole eligibility, and that's what he's got. The only remedy he's entitled to is a remedy if he's suffering an injury. He's not suffering an injury. He's got a lawful sentence. This court shouldn't vacate an entirely lawful sentence and remand it for a hearing at which you're either going to have the Superior Court function as the parole board by taking into account his post-sentencing conduct.
He needed to be resentenced.
No, that's exactly what Diachenko says does not happen, did not happen, and has never happened.
Judge Locke said he's initially he's parole eligible in 30 years, right?
Everyone agrees that under the current interpretation of the aggregation of the sentences, he's parole eligible approximately 2.5 years from now.
Right.
And Judge Locke said...
Wasn't there a proceeding before Judge Locke in which he said that?
I don't recall if he said exactly those words. At the proceeding in front of Judge Locke, the defendant said, I'm entitled to a Miller hearing, basically, but Miller plus all the rehabilitative stuff. And then at the end, and he said, by the way, I have another psychologist who's examined him, and it happens to be Dr. Kinsherf, who examined him at the transfer hearing. Now he's examined him again. I want to present Dr. Kinsherf to testify about something now that he's got a new psychological exam. But, you know, the fundamental flaw is Judge Locke said, oh, we're going to have a hearing at which I'm going to hear about, and by the way, if you read the transcript, I don't think Judge Locke is clear what this hearing is going to be. I certainly don't understand what it's going to be and where he's going and what evidence he's going to take. First he said, well, I'm just going to hear about evidence about the crime and about his state of mind or frame of mind at that time. And it turns out, well, there's transfer hearing transcripts and there's psych reports. Well, okay, make those available to the Commonwealth. Well, now there's another psychologist who examined him recently, plus there's his entire post-incarcerative history. So are we having a parole hearing? Because that's exactly what it sounds like. That's where we're going.
What kind of hearing would a judge have now if there were 2 homicide victims and the question was whether or not it should be consecutive or concurrent sentencing that's imposed? Because the judge would have the discretion to make that decision.
Yes, I would suggest that unless the sentences are going to, in the aggregate, constitute life without parole, that you don't exactly have a Miller hearing. Now, there is no doubt the judge will take into account the offender and the offender's youthfulness and his youthful characteristics. But the idea that you're having, you know, a hearing reserved for a death penalty case or a life without parole case just seems inapt.
Well, if the judge is going to take them into account, isn't he entitled to take evidence on that?
Sure, he's entitled to take evidence, perhaps, in his discretion, but I don't think he needs to have a hearing and have evidence on that unless...
But do you say he can't?
Under today's current sentencing scheme, if you have a multiple murderer who's going to face up to 30 years before he's parole eligible on murder number 1, and another 30 years before he's parole eligible on murder number 2, the judge has discretion to take evidence. Yes.
Is it your view that if a juvenile defendant, let's say a juvenile defendant is convicted of killing somebody, and today he gets life with parole. He then goes to prison. His first week in prison, he kills a prison guard, still a juvenile, and he's tried and then convicted of that. Are you saying that there has to be a Miller hearing as to whether or not the second killing, the sentence on the second killing has to run concurrently versus consecutively?
Absolutely not.
Well, so why would that apply? Why does Miller apply here?
I don't think it does. It doesn't apply. It can only apply if the aggregate sentences mean that the defendant absolutely, undeniably, unequivocally dies in prison. That's when you have a Miller hearing.
All right, thank you.